general approach to COVID questions that you can take with you when you're faced with any kind of COVID question, as well as drilling down to some of the main things that seem to be a continued issue, things like meetings and how to address those meetings, as well as what the Safer at Home order says and how do you open your amenities and reopen them, and what do you consider when you're opening, schools specifically. We're going to go into all of that, but as Frank said, please put your questions in the chat box, because you might have come here to talk about covenant enforcement or maybe collections or something, and not related to the specific things I'm talking about today. So I would like to get to your questions, and as Frank said, there's maybe 16, 17 people. We should be able to get to all of them. I have, I know this is for an hour, and I timed it so that I can have at least 10 minutes at the end of the program so we can discuss any of your questions. And with that, I'm going to go ahead and share my screen. One thing, Frank, really quickly, I sent you a handout. I don't know if that was sent to anybody. It's just the PowerPoint that you can take notes on, but I am going to share the screen so you can see my PowerPoint. Okay, let's see. Okay, hopefully everybody can see the PowerPoint. Can you give me a thumbs up, Frank, if you can see it? Hopefully everyone can see that. Excellent. All right. Well, let's go ahead and get started. So today, we're talking about COVID-19, and there's a lot to talk about. Whoop.
Follow up on that note to everyone that you and I spoke, and my feeling is
somebody
with what you're.
Okay, Frank, you're muted. Can we have everybody mute until the actual questions, unless, I don't know who was asking that question. I don't know if it was from somebody from CAP, but I'm gonna go ahead and get move through here, and then we'll try to answer all the questions at the end. Okay, so first, our slide, obviously additional resources. We do a lot of education, and so feel free to get onto our website. There's a ton of information there that you can go directly to specific things like we have a post-pandemic playbook sort of article that discusses all these other things. We have a temporary drop-down called COVID-19 resources on the website. So if you get on the website and you just want to know about COVID, make sure you get onto the COVID-19 resources section. And here's some of our other resources as well. Okay, I have to do the attorney thing, which is I am an attorney, so this is a disclaimer. And so just got to remember that what I'm providing today is guidance only. There's a lot of specific nuances with respect to the order and with your governing documents. So what I try to do with these webinars and classes is to issue spot, give you things to consider and think about. And then if you need actual legal advice, you should go to your attorney, because they're going to look at your specific documents and your circumstances as an HOA. So remember that thing, and things change tomorrow. The orders change. It's tough enough just trying to move forward with all the changes from the state, but then local orders are in effect as well. So things that I say today might not be in effect 2 weeks from now. So just remember that. All right, so let's start with something that I definitely need you guys to remember, and I'm going to spend a little bit of time on this next slide. But there's two overarching principles that I want you to remember whenever you are faced with any kind of COVID question, any COVID-19 question, because these, we've weathered sort of the initial shock and awe of COVID, and there is, as I've said so many times, there's really no pandemic playbook. So we're kind of writing that playbook as we go along. And you guys have probably faced floods and fires, but nothing like this. This is more like the stuff of movies or something, zombie movies or whatever. But one thing remains the same, and it's these two principles. When you're making decisions, remember these two principles: fiduciary duty and business judgment rule, because it's really, they have to do with liability, and they should serve as the foundation for all your decision making. So let's go ahead and look at each of these. So fiduciary duty. I know that if you've gone to classes before with us or with anyone else, or if you've been on the board for quite some time, you've probably heard this term. But if you haven't heard the term, it's very important right now because your decisions are going to be based on the concept of the fiduciary duty. So what is it? What it means is it's a position of trust. So when you were elected onto the board, or when you were coerced to getting onto the board, or when you went to the bathroom during the annual meeting and you came back, you were a president or something, whatever the reason, you're now on the board. And what that means is that you were entrusted with the property, the assets of the association, to maintain the common elements, to make sure you make wise financial decisions, to enforce the covenants. You as a fiduciary were entrusted with the property and the power for the benefit of another. And the another is the association. That's a concept I'm going to go back to many times, because oftentimes boards will forget that it's the corporate entity that you owe your duty to, your fiduciary duty to. It's not to the board. It's not to the homeowners in general. It's not to the loudest homeowners or the angriest homeowners who really want you to open the pool or whatever that decision is. Or the ones that, I hate to say it, some people are in dire straits with respect to assessments and delinquencies. And you can't make your decision based on certain groups of people. You always have to be looking at the association as a whole. And that applies to any kind of COVID-19 decision. And you should also be looking at things in terms of not just reacting to COVID, so not today's issues, but also looking into the future and trying to make sure that whatever decisions you make today don't then negatively impact the future as well. So to be a fiduciary, what does that mean? It means that there's a lot of different things that fiduciaries have to follow to comply with their duty. But the main one that we're going to talk about today is the duty of care, which means that as a fiduciary, you have to act in good faith, prudently, and in the best interests of the association. So this is overarching principle number one. You need to, good faith, we'll talk about each one. Good faith is that's the easiest one. Just don't act in bad faith. Don't act maliciously. Don't single somebody out and make decisions because of that person. So that's probably an easier one when it comes to COVID-19. But prudently is a very, very important one. That means making an informed decision, which we'll go into detail as well. So it means asking a lot of questions, particularly when it comes to decisions that hit the pocket, that are going to cost a lot of money, or decisions that impact a lot of the homeowners, such as the decisions that you're making for COVID-19. So prudently just means informed, ask a lot of questions. And again, in the best interest of the association, which is, just remembering to take off your homeowner hat and put on your association hat and make your decisions with that in mind versus homeowners or board members. So when you're trying to figure out how to respond to a particular decision, a lot of it comes to your authority and what you have the right to do or what you have the duty to do. And that is driven by your governing documents. So you have the importance of your governing documents. That's everything is driven by what's in your declaration, your bylaws, your articles. There could be a class that is discussing just that. And when it comes to COVID-19, when you're looking at things like, well, what do I have the right to close the common element facilities? So that's a pretty typical question under COVID-19. So I doubt there's anything in your documents that says something as specific as, do I have the right to respond or react this way to pandemics? There's nothing that says anything about pandemics, but most likely there's something in there that says you as a board of directors have the right to regulate the common elements. That's your jurisdiction. Whatever those duties are, sometimes they're spelled out in the declaration, sometimes in the bylaws, sometimes all throughout all the documents. But if somebody challenges your decision, a court's gonna look at where your authority is. And the first place they're gonna look at is the governing document. So just remember that as it relates to COVID-19, when you're questioning whether you should do something or not do something with respect to the common elements, chances are 99% of those governing documents say that you have the right to regulate completely the common elements. There's very little that you don't have the authority to do with respect to the common elements. So just remember the importance of your governing documents. The importance of state and local orders. So we'll go into this a little bit more detail later, But you'll note that the state order doesn't really speak directly to homeowners associations or condo associations. There's some of the language that's used in the state order that refers to condos, and the Colorado Department of Public Health and Environment, CDPHE, they issue guidelines that are pursuant to the governor's Safer at Home order. And those guidelines actually do directly state homeowners association. But when we're thinking about what we have the right or right not to do or to do, or what we should be doing or not doing, the state and local orders are really important because it's in making that prudent, informed decision that you're looking at things like the state or local order to make your decision. Even if it doesn't directly say this applies to HOAs, and again, the CDPHE guidelines do say that, but even if this order doesn't say that, you need to make a decision as a board. Do we open the pool? Do we shut the pool? And you're not a virologist, you're not a health, maybe you are, I mean, you're not a health expert, you don't know, you're not a pandemic expert, so you need to look to other experts to make your decision. And the state and local order, that's one area that we're going to go into that you need to look at, because you need to know how to base your decision and how to comply with the order if it does imply that homeowners associations are affected and impacted by it. Also need to look at your local orders as well. We'll go into that in detail too, but the state order says that the local governments can be stricter, and they also say the local governments can also be less strict if they apply for a variance. So it's important wherever you are that you look at those as well. Finally, the importance of experts. With the state and local authorities, that's the guidelines that you're looking at, but there's other experts out there as well. So you can look at the CDC guidelines. All of this stuff is on they have some great pool guidelines that you can refer to. You can look at, maybe you have a tennis court. You can look at the U.S. Tennis Association website, which has fantastic tips and recommendations and guidelines for both the players during COVID as well as the tennis court administrators. You can talk to your attorneys, you can talk to insurance experts, talk to your pool vendors. They might have great ideas and recommendations with respect to pool reopenings. So the importance of experts, again, is to make sure that you show that you are making an informed decision, so that after all of this, you can then say, okay, court, I acted in good faith, prudently informed, and in the best interest of the association in making the decision to do X. And that's really what you need to do. I do want to say, tip one, stay in your lane. What I mean by that is, yes, you look at the state health orders to figure out what your duty is. And yes, you definitely look at your governing documents to figure out what your duty and your authority is. Don't exceed that. Don't exceed your jurisdiction. Don't go off and think, okay, the order addresses this, so now I'm going to be the Safer at Home order police for the association. You have no authority to enforce the Safer at Home order. What you have authority to do is enforce your own governing documents, which are then informed by the state and local orders. You don't become the COVID cop. If you exceed your authority, then that invites liability. It creates expectations that shouldn't be there. Just don't do it. So just stay in your lane, okay? All right, let's go to the next thing. So hand in hand with the fiduciary duty slide is the business judgment rule. This is great. Even if you are not even dealing with COVID-19 decisions, this is something that you need to know because it protects you. Now, the business judgment rule is essentially a court-made rule where, and there's also language in the statute that also supports the business judgment rule. But essentially, it's a rule that says, as long as the board of directors acts according to the standard of care that we discussed in the last slide, then you will be protected as a board member from liability. Even if your decision is wrong, let's say you make a decision and it ends up being wrong, as long as you can show that you acted in good faith, prudently, and in the best interest of the association, you're going to be protected. And why is that? It's because the courts don't want to second guess your judgments. They want to defer to you. They know you're volunteers. You're not being paid as experts to do this stuff. And they also know that if you were liable for all your actions taken on behalf of the association, nobody would serve on the board. So they recognize that, and they want you to just serve on the board according to that prior standard, which is not very difficult to meet. If you are one of those boards that does get paid, because I know some boards that do get paid for being on the board, and there's nothing under Colorado law that says you can't be compensated. Don't go running wild with that statement. Usually the governing documents say you can't be compensated. But if you were compensated, then your standard of care is increased. It gets higher. All of a sudden you're being paid for your decisions. You don't want to be compensated because you potentially don't get the protection of the business judgment rule. So it provides protection from liability. However, you need to show that you met the standard of care, so you need to show that you made an informed decision. That's where the importance of relying on experts is key to being able to take the protection of the business judgment rule and apply it to yourself. When you're making these decisions, when you're deciding to open or keep the pool closed, when you're deciding whether or not to allow somebody in, a construction company, because you're not sure that they can meet the social distancing protocol, all that stuff, you need to rely on experts. You need to get opinions from your attorney. You need to talk to your insurance coverage specialist. You need to talk to your manager that provides day-to-day expertise. You need to look at the guidelines, the orders, and all of that. And that shows, again, that you made an informed decision. So when you're feeling angst, or if you're under a lot of pressure, which I know a lot of our boards are under a lot of pressure right now, and unfortunately, I'm going to tell you a truth here, which is, regardless of what decision you make, somebody's going to be angry. You're not going to be able to please 100% of the people 100% of the time. I know you probably want to do that, but that's not going to happen. So push that thought aside and just realize my decision, as long as I make it according to the fiduciary duty standard of care, is going to be protected. I'm not going to be liable. So tip number 2, paper trail that due diligence. Make sure that you have gone through and recorded the Zoom meeting that you had with your attorney discussing whatever the question is. Got that written opinion letter. Obtain the waivers or whatever else that you are doing to show that you made a good decision. Because again, if somebody challenges your decision later, or somebody says, hey, they opened the pool, I got sick at the pool because they opened it and they didn't do all this other stuff. You know, this is what the court's going to look at. How did you make your decision? What did you do that was in the best interest of the association and prudent and in good faith? What is all that? And it's much better to have a documented paper trail versus just a board member saying, I did this, and then there's nothing showing that they actually did. Okay? So those 2 overarching principles are really, really important when it comes to facing any COVID-19 decision where you're unsure what to do, as well as any other decision that you have as a board, because this applies to any decision, and it protects you from liability, and it also establishes how you should make your decisions. Okay, so let's go ahead and move forward and talk about the Safer at Home order. So the Safer at Home order, for those of you who haven't even seen it, if you look at the Colorado Department of Health and Environment, that's the, let me see if I have the website. I'm not sure if I do. You can email me afterwards, but it's the Colorado Department of Public Health and Environment, I apologize. That's the website that you look at, and there's a drop down that just says COVID-19 resources or COVID-19 something, and then you go down and it'll show the executive orders and the applicable orders. That's where everything is. That's where they update everything whenever the governor makes a different decision or a new decision or amends the order. And we're on our 6th amended order now, Safer at Home order. The most recent one just got amended on the 5th of June, and it's applicable until the end of June. Unless it's amended or rescinded or changed otherwise by the governor. And we always send out information to all our clients, our managers, and anybody who subscribes to our publications. Doesn't matter whether you're a client or not, but we always keep everybody up to date. So the public health order in question is 20-28. And when you go onto the CDPHE's website, you'll see that order. It's many pages. I think it's probably 40 pages or so, but not everything on there applies to HOAs or is impactful to HOA, so you don't have to worry. There's only a few sections that might be applicable to you, but in general, this kind of drives how you can be out of your residence during the pandemic. Also on the CDPHE's website is the guidelines that were issued last week, or maybe it was the week before. I think it was Monday of last week. The guidelines address recreational activities such as pools and play and tennis courts and those kinds of things. So you definitely need to get a copy of that as well, or just review it on the website so you know what we're talking about. But in general, first we had the lockdown order, which says nobody go outside for any reason except for necessary things, and then no gatherings at all. That has been obviously relaxed under the Safer at Home order. I think we're on phase 2 now of getting through the COVID marathon, is what the governor calls it. So in general, I just want to give you some of the essentials. It essentially says stay in your residence. And by residence, that means, this question sometimes comes up, that means your home. You know, that doesn't mean if you're in a condo building that the residence is the entire building. It means your unit in the condo building. If you're in a high-rise, for example, I don't think that staying in your residence means you can stay in the entire building. It just means your unit. So you stay in your residence unless you're performing or using a necessary activity, which relates to the whole personal recreation thing, or unless you're a critical business and you're performing or using a critical business. And these terms are all defined in the order. It also says travel should be limited unless, you know, necessary travel, but there's all these different exceptions and things that you can do. Gatherings of more than 10 people. So that's where the key is. Before it was no gatherings. Now it's more than 10 people are prohibited unless it's an essential activity, and there's some exceptions as well as conditions for social distancing protocol with respect to those gatherings. So the state order itself, and I just kind of breezed over some of the main things because those are the things that are really coming up with associations. I'll talk about how they impact associations here in a second. There are other areas that you go into detail, so definitely take a look at that order. And if you need a copy, you can email me at the end of this and I'll get you a copy. So how should it be used? So again, with the business judgment rule and with the fiduciary duty, it should be used as a basis to support your decision-making with respect to anything that could be COVID-19 related. And so in what areas could the order impact the association? So number one, primarily, is the regulation of common elements. There's language in the order that says, okay, you can now do this and open these amenities. However, here are all the conditions. Or here are all the things that you can't open, or here are things that you can open, but look to your local order for more specificity. So it really, when it comes to common elements, and that's just not the pool or the recreational areas, but that's every area. The Safer at Home order says things like, here's the increased protocol for cleaning. So that could affect in the high-rise condos where it's a secured building and there's a lot of traffic going in and out. That remember before when I said stay in your lane and only comply with your governing documents in terms of your duty? Well, one of your duties pre-COVID is maintain the common elements. So that's the same duty that you have post-COVID or during COVID, but now that's a heightened duty. That's going to be informed by the Safer at Home order. So things like heightened cleaning protocol, heightened disinfections. We'll go a little into detail with respect to the pools when it comes to the type of ongoing cleaning. However, with a lot of the orders that they know specifically what you should do, just gives you some recommendations and encourages you to do X, Y, and Z. That's why you need to look at other experts, like the CDC guidelines, with more detailed information, or your pool vendor, or your regular maintenance vendors, to give you, or whoever, to give you more guidance on that. And then you ultimately make your decision. So the other area it impacts associations' access issues. That's to do with, again, when I think about high-rise condos where there's security, or even with regular associations, single-family home associations where there's maybe gated areas, or even the ones that don't have any gated areas. The questions have been, why should I allow this person in? I don't think they're a critical business or a necessary activity. They're not performing a necessary activity. There are so many things that nuances to the order. So if you get questions about, can I allow this person in? Your attorney should respond to that. They should be looking at that and saying, well, do you have the right to exclude them in the first place? Because remember, everything comes back to the governing documents. I'll give you one example. One thing that comes up, that's come up, is Airbnbs. If you didn't have the right to exclude or limit short-term rentals before COVID hit, if you didn't have something in your governing documents that said short-term rentals are prohibited or short-term rentals are regulated, some kind of leasing restriction. If you didn't have that before, you don't have that now because of COVID. You don't have that because there's an order out there that says, hey, these are the necessary activities or these are the critical businesses that are out there. It's not something your role and your obligation and your duty and your authority is not magnified by COVID-19. It is informed by the safer at home orders. So you can figure out what's in your jurisdiction, what you need to comply with. One exception to that is maybe many of you are in those high-rise condos that I talked about a second ago. That's the one area where, it's a secured building. There's probably something in your governing documents that does allow you to limit access. There's probably an argument that you can make that, hey, I'm trying to be safe for my residents, and it's better to have these security or access protocol in place so that, because one person coming in that's infected could easily infect everybody else very quickly. That's very unlike all the other associations that don't have that kind of environment. So that's the one area where I think maybe you have some wiggle room. But again, talk to your attorney because it really does depend on some of the documents. Other areas, limitations on construction projects is certainly something that could be affected if you as an association were deciding to do a roof project. And the scenario is usually that you've budgeted for this back in January, and now you're coming forward and saying, well, wait a minute, should we continue? Because I don't know, it might affect, are the construction workers going to be able to maintain the social distancing protocol? Should I do this because of all the increased traffic and all the contractors coming in back and forth? So again, there could be a class just on these specific topics, but on that particular topic, I'd say, think about the project itself. Is it something that can be deferred safely to next year or much later in the year? If it can be deferred safely, then you should be considering this in terms of whether or not you should reschedule that project or renegotiate the contract with your construction company. Or maybe there's something in the contract that allows you to say we can't move forward because it's impossible to do so under the order. Lots of legal nuances there, but your decision is it safely deferred till next year? That's what you should be thinking about. I would not say a roofing project is safely deferred because, if the roof's going to fall down or if water's getting in and it could be creating mold, those were one of those things where I think it is priority. And you should consider moving forward with those kinds of projects. So that's another area, limitations on construction projects and enforcement issues. Obviously, if you might want to relax some of the things that you wouldn't normally relax. It doesn't mean that you stop your duty to enforce. It just means that certain types of violations should take priority over others. Things that would affect the injury or have injury to person or property, definitely need to enforce those. Somebody's not weeding their yard properly or hasn't painted something, maybe those are relaxed. Maybe you say, we know this is a violation. However, because of the safer at home order in place, we're going to temporarily allow you to wait until September or whatever it is, some kind of relaxing of it, but you're not stopping enforcement. You're just creatively trying to react under COVID-19 circumstances. And then lastly, there's collections, obviously. The safer at home order doesn't discuss assessments, but there's pending legislation, which if you want to hop on another webinar after this, we have one with Altitude that's going to discuss the legislation. So if you want more information on that, just get onto our website. But assessments, probably the big issue is people not being able to pay because they're either infected by COVID or they lost their jobs or they got furloughed or whatever, and they're having problems with paying their assessment. So the only thing I'll say about that really quickly is that, again, you need to make your decision according to the best interest of the association. While I understand completely the desire to give, have some kind of moratoriums or something that allows people to more time, or allows them to pay in a different manner. That's all good. I think that you should respond and be mindful of this situation. What you don't want to do is, number one, stop collecting altogether. Because if you stop collecting now, or if you, number two, stop levying assessments altogether. If you do that now, then that's going to affect you 3 or 4 months down the road. Then all of a sudden you're levying special assessments because you didn't collect before. Just keep in mind that assessments are the lifeblood of the association, so you need to continue to bring those in, but you can do things like have longer payment plans, have more time before you turn over somebody to the attorney, adopt a moratorium, a resolution saying, we're going to do this with respect to this period of time because we recognize COVID-19 circumstances. Maybe you, I know there's a couple of waive late fees, waive interest. It's only a little bit of stuff, but still it's something that you're doing in reaction to this. Just don't stop collecting altogether. Okay, so tip number 3, we talked about the state order, but you need to also look at your local orders. I don't have, I mean, we're thinking of putting together on our website specific local orders and the specific ordinances and the key issues of each one. But if you look at the CDPHE website, they do have a section on there that discusses each county's ordinances. I'm positive they have a section that says which counties have been granted variance, because I've looked at that myself, but I don't know if the website goes into detail about the general ordinances. But most of them I've seen defer to the state order. They don't have their own specific things. Now, Denver, obviously, they have their own thing going on. Boulder does as well. They have very specific things. I mean, they go into different things like which golf courses can be open and which golf courses are not. You know, I mean, that was the order a month ago. I don't know if that's changed, but keep in mind that everything we talked about today about the stay safer at home order is just the sort of the general order, but things can be strict. All right, so that's tip number 3. Let's go to meetings, and then we'll go to specific pool openings. Meetings I want to go through into detail here, and these things come up all the time, but essentially the main question that comes up is, are you prohibited? One of the main questions from annual meetings under the Safe at Home order. And the thing that you got to remember is the Safer at Home order says you can't gather or have public gatherings or private gatherings for more than 10 people. And so while maybe you can with a very small association, you can do that and you can maintain the 6-foot distance. But for most annual meetings and associations, that's not doable. I have one association that has created a bunch of different rooms where they have 10 in here and 10 in here and 10 in here. And then they have a main room where everything is sort of the main room where they're filmed and everybody can watch. And so they're all kind of physical, but it just, you know, it's something that you have to figure out for your association, whether you can maintain the social distancing. But most of them are saying, no, we're not going to do that. We're going to think of the alternatives. You can't cancel your annual meeting because the Colorado law does require you to have at least 1 annual meeting. So no, you can't cancel it just because you can't cancel COVID altogether and all that. But here's considerations that you can do. Most associations, you know, you can delay, but not for too long. Think of the things, business must go on. So you have decisions to make. You need to adopt your budget. You need to do all that. So most associations are considering some kind of virtual or remote meetings instead. So I want to talk about those considerations for homeowner meetings, and then we'll talk about the board meetings as well. So first, under Colorado law, everybody must be able to hear each other, which means the only thing that really means that's important in my mind when it comes to hearing each other is if you have Zoom, if you're using Zoom or GoToMeeting, as we're doing today, you're typing in your chat box questions and I'm going to address them later. To technically comply with the Colorado law on being able to hear each other, just keep in mind that instead of having somebody type a question in that you're going to recognize at an annual meeting, even though that's maybe easier, in order to be technically compliant, they're not hearing you if you're typing into your question and then reading it. Somebody else is reading it. Maybe you say, you know, for homeowner forum, we're gonna recognize, we're gonna unmute you so everybody can hear your question. Or maybe you do something such as allow people to designate the moderator to be that voice for the person when they're speaking. But whatever it is, it says they have to hear each other, and you're not technically compliant if you're just typing in a question in a chat box. So that doesn't apply today because we're not having a meeting, but just remember for annual meetings. Meet the same Colorado requirements for notice and the same kind of Colorado law requirements that you would apply for any kind of meeting. So, you know, notice, time and location. Location, you could probably argue the internet's location, but the better thing to do is say the location is the address or the place that the person who's actually holding the meeting is that place. Even though you say everybody is able to just participate via virtual meeting, it would be better to have an address, a physical address versus saying the internet address. Meeting protocol, just have instructions, have a virtual meeting policy that talks about what the instructions are for checking in, for use of proxies, recognition by the chair, so that, and all of this could be actually also in your conduct of meetings policy, so make sure you incorporate those things. Secret votes, how do you handle secret votes? So, you know, how do you preserve the secrecy? I know that there's one program, at least that I've heard, the Election Buddy program or something, that there is secrecy, that you can somehow cast a secret vote and be able to document it for later purposes, document how many people voted. And I know in Zoom, they also have a polling ability as well. So maybe you can do it under Zoom. I don't know technically, but most programs don't have the ability to preserve the secrecy. So if you don't have that platform, what we always recommend, and what we're talking about is you have to cast, if you have a contested election, which means more people are running than positions open, which maybe never happens, you're just trying to get people to run. But if that does happen for your association, then what we recommend is during the annual meeting, you actually just have the nominees discuss why they should be on the board. You have that piece. You have the call for nominations, and then they speak to everybody on Zoom or wherever, saying this is why I should be on the board. And then that's the only thing on the agenda. The second piece would be outside of that meeting, after the meeting, which is voting by mail. So the agenda for the annual meeting is call for nominations, and then the candidates speak. And then if it's a contested election, you hold the actual vote by mail. And that way, that's easy. You meet the voting by mail protocol, which is a completely different topic, which we're not going into today, but you can easily meet the double envelope system, so you can preserve that secrecy. And we've got stuff on our website about that as well, if you're wondering about that. Okay. Finally, record keeping. Remember that every one of the things under Colorado law requires you to keep certain records for inspection, and one of those records is any kind of ballot or proxy or document that's used for an election or any kind of action by the association. So whatever meeting platforms that you do use, and I know Zoom has this and GoToMeeting has this, you need to have some documentation of whatever actions are taken for the election, or if it's not a contested one, or for the budget, for example, ratification, something that you're going to be able to produce those proxies. And so proxies are going to be given to you before the meeting anyway, via some other method under your instructions, but you should be able to print out the record of who attended the meeting, the check-in piece, the records of the vote. You should have some ability to do that with your virtual meeting platform. And I'm pretty sure all of them have that ability. Just know what how those controls work. Okay, so other things, and just, you know, I'll jump really quickly to be prepared for technological issues. I mean, I think that's a big thing, maybe not with board meetings, because you guys are very probably familiar with board meetings, but for annual meetings, just have clear instructions how to sign in, whether proxies are, how they're going to be used, you know, have people test their equipment, tell them that who's going to be available to answer the questions, they can get on the meeting and all that. Just be prepared for technological questions. Okay, so meetings for boards. What are considerations for boards? Same requirement as owner meetings under Colorado law. As long as everybody can hear each other, then you can take action at a board meeting as well, virtually. So you can call in. I always say virtually, but that doesn't mean I'm excluding people just conference calling in, even though they can't see anybody. So any kind of meeting where you're not physically face-to-face, is what I'm encompassing here. So owners can, remember that owners can attend all board meetings except what's in executive session. So just keep that in mind. If owners want to attend a meeting, then you should provide them the sign-in information. Doesn't mean that you have to provide them the mechanism for getting onto the meeting. So you don't have to give them a laptop or something, but just give them the sign-on information. And you might want to be proactive and just put it on your website and say, hey, we meet regularly first Tuesday of the month, and here's how we're meeting for the next few months on Zoom, according to this information. Also remember that if anybody attends as an owner at a board meeting that's conducted virtually or remotely, you have to provide owners the opportunity to provide input and feedback prior to making a decision. So if you have on the agenda that you're going to vote on who you want to hire for a landscaping contract, before you actually vote on that, you have to allow a reasonable number of people that are in attendance to speak for or against or give input on that decision. You can determine when that happens. It could be right before you make the decision, or you can say, we're going to have a homeowner forum, and if you're here to talk about X, then go ahead and talk about it now. That's up to you, as long as it's before you take the decision. And finally, executive sessions. Keep in mind that Colorado law says you can only go into closed session for certain things. I'm not going to go into detail about that, but just remember it's in the actual, I'll give you the actual site so you know where to look at. But if you look under Kiowa, which is the Colorado Common Interest Ownership Act, and you should know that if you're on the board, remember Kiowa is the statute that governs all HOAs, most of them. The section is 38-33.3-308, subsection 4. And I think this is being recorded, so you should be able to get that again if you didn't hear that. But that tells you the session categories you can go into. Just keep in mind that when you have a virtual meeting, that most programs will allow you to have people exit into the lobby and hold them there until you're done with your executive session and then bring them back. Or you might want to just say executive sessions are at the end of the board meeting, so you can just have everybody disconnect and then you can conduct your executive session. And also keep in mind that this is a problem no matter what, whether you're in executive session for COVID or some other reason, you don't really know who's in that room with that board meeting or who's actually listening to that conference call. And unfortunately, there are situations where we have what I like to call the rogue board member that leaks information that should be confidential and privileged. But that's just something that happens normally. And so we kind of hope that everybody complies and doesn't act inappropriately. But if you determine that that's happening, then you need to call that behavior out with the particular board member where it's happening. Okay, so finally, can board members vote by email? Yes, this is something that's allowed per Colorado law. The thing that I want to remember though is, and so this is outside of a virtual meeting, this is actually all by email. So yes, you can vote by email, but remember that you need to look at your bylaws first in terms of procedure for that, as well as approval for board meetings votes by email. So what I mean by that is Colorado law says, yeah, you can vote by email, and it doesn't say email, it says you can take action outside of a meeting. So if you can take action outside of a meeting, but we defer to whatever's in your bylaws. And a lot of bylaws say you cannot take action outside of a meeting as a board unless you have unanimous approval. I mean, a good 60–70% of the bylaws say this. So if that's what your bylaws say, follow your bylaws or amend your bylaws to get rid of that language. So if you're just sending emails around thinking, oh, as long as I get a majority of a quorum of directors to respond in favor, then I'm good. Well, you're probably not good. So you need to look at your bylaws. Secondly, if your bylaws don't address it, and when you're looking at your bylaws, don't look for the term necessarily email, because a lot of the bylaws were written before email was even a thing. So look for terms like action outside of a meeting or consent to corporate action. So let's say your bylaws don't say anything about action outside of a meeting, or they defer to the statute. The statute is also different than a regular board meeting. The key is with the statute, you send an email to everybody with a deadline date. And as long as a majority of the directors in office vote in favor of the proposed action by the deadline, and assuming none of the directors demands a physical meeting by the deadline, then you can go ahead and move forward with that action. This is different from a regular board meeting. I want to make sure you understand this, because at a regular board meeting, if a majority of a quorum of directors attends a regular board meeting, then you can pass the action. That's not the same approval requirement under the statute. So let's say you have a 5-member board, and a quorum has to show up, and that's usually a majority, so that's 3. So theoretically, 2 people, which is a majority of that quorum, can pass the decision. Not the same under the statute for action outside of a meeting. It's a majority of the directors in office that have to be in favor of the action. So if you have a 5-member board, a majority of that 5-member board is 3. So you can't have 2 people approve an action outside of a meeting under the statute if you have a 5-member board, but you can do that at a regular board meeting. So if you have any other questions about that was too confusing, then you can contact me offline there. So again, Colorado law procedures, just remember these are something that only applies if your bylaws don't prescribe something else. So we already talked about tip 4. Let's move on. All right, let's talk finally about considerations for reopening as well as the pool. Here are all the things you should be considering, because it's up to you to decide. You have the right to keep it closed if you don't think you can meet all these, and you have the right to open it as long as you feel you can satisfy all the conditions.
Melissa?
What you should consider, state and local law. Yes. Yes.
Could you repeat, I don't know if it was just my audio, could you repeat the intro to that section? I think your audio just got caught up for a minute there. That's okay.
Sure. Absolutely. So considerations for reopening your amenities. Remember that you have the right to regulate the common elements, and you have the right to keep it open or reopen it or keep it closed. It's up to you. There's no duty to open those amenities just because the state has said you can, and here's what you need to do to comply. You can also make the decision to keep them closed if you feel like you can't meet these considerations and the conditions. And you can also open it, again, if you can meet the conditions. And you've made that informed decision considering everything we'll talk about here. So what you should consider, state and local orders. We already talked about that. The state order has very specific, first of all, the section of the state order is section 1H, H as in Harry, 2. So 1, like Roman numeral 1, H2. That's the key when it comes to opening your amenities. And so definitely look at that, because that's the area where it talks about playgrounds, pools, and everything. But consider the order, the state order, and the language in that order, which essentially treats indoor swimming pools differently from outdoor swimming pools. So keep that in mind as well. But it essentially allows outdoor swimming pools to be open up to maximum capacity of 50%, or it's also, or not to exceed 50 people. So whatever is the lower amount is what you should follow. So that's pretty clearly stated in the order, but then you need to look at CDPHE guidelines, which again, if you need these copies, you can get on the CDPHE website, or you can email me and I'll get them to you. But the guidelines go into more detail about things. Here, I'll just give you some examples, but read them for yourself. For outdoor swimming pools, limit the pool to 50% capacity, up to 50 people, whichever is fewer. You're encouraged to establish a reservation system, which we talked about here in the next slide here. Take such steps, closing off lockers, but you keep the restrooms open. You keep the showers open, but you close the locker rooms. I mean, these are the things that they say for outdoor swimming pools. There's more, but again, read the guidelines. Indoor swimming pools is different, up to 25% capacity or 50 people, whichever is fewer per room. So they go into more detail about the showers and how often you're supposed to clean them, once an hour. Making sure you clean the equipment and kind of highly, easily touched surfaces often. They don't say specifically when. They talk about cleaning any equipment that is used between users. So I want to talk about that a little bit more in the next slide, but So consider the state and local orders as well as the CDPHE guidelines. Consider the expert recommendations we already talked about, CDC, your attorney, your pool vendor, your insurance professional, and I'll talk about that too. Type of amenity, how much traffic do you go that gets to this amenity? Is it the clubhouse that gets very little traffic? I don't know. Or is it the swimming pool that gets a ton of traffic? That can be used into considering whether or not you should open or keep it closed. The order of opening. You don't have to decide to open everything at once. You can stagger it in based, again, on the type of amenity, the feasibility in terms of maintaining some of these additional protocols, the cost to administer these protocols. If you have to what's your disinfection plan? If you have to disinfect the furniture, I would recommend just getting rid of the furniture during the pool season. But if you have to clean the bathrooms once an hour, if you have to monitor the check-in system or the reservation system, if you have to monitor that people are keeping each other 6 feet apart. I mean, these are all things that you need to do if you're going to open the pool. You need to make sure that you are doing what's necessary, what's reasonable. You don't have to have somebody 24/7, but what's reasonable to administer and enforce and monitor these social distancing protocols. And that might cost some money. Some associations have a ton of money and they have unlimited resources. Others don't. So you need to consider this. You need to figure out whether this is really an amenity that everybody wants open and they're okay with, for example, hiring additional staff that will increase their assessments. But that's what they want, so you need to consider it. Liability concerns, I'm sorry, I'm a little late here, but I'll try to quickly sum up here. Liability concerns. Again, it'll be very difficult to hold a board of directors liable for breach of their fiduciary duty, or even for somebody's claim that they were infected because of what the board did or did not do. The causation is not there. It's very difficult to figure out whether or not a person got infected because they were at the pool versus somewhere else. Plus, the standard of care I just talked about earlier, which is, if you act according to that standard of care, you're not going to be held liable. The problem is there's no insurance. I've talked to so many carriers, and with respect to all other decisions, D&O, the directors and officers insurance, would usually kick in to address that and defend you. Here, most insurance carriers are telling me there's an exclusion for these types of claims. So you have to remember that as well, that if you do get sued, even though you wouldn't be liable, you still have to incorporate what are those costs to defend you as board members if you do get sued. So again, when you're thinking about that, you need to do as much as you can on the front end to minimize any kind of even remotely valid claim against the board. And that's why you want to do all this decision making and this consideration and asking all these questions. The importance of communication is so key. If you decide to reopen, then you need to communicate, yes, we're going to reopen, but here are all the conditions that we're reopening for. Here are all our revised rules and regulations that incorporate the social distancing protocols. Here's what we're going to be doing to clean. Here's why we're taking out all the furniture, because we don't want to have to clean all the furniture every time somebody else uses it. And so these are the things that you need to put into your communication if you decide to reopen it. Here we're going to use waivers. Here's our new signage that addresses COVID-19. So let's talk about the pools, then I'll open it for questions. One more thing. If you're not going to open it, this is key as well. Making sure that you communicate why. It's not made lightly. Here are the costs. It's only for probably one summer. There's likely no insurance available. Here's the amount we're going to have to increase the assessments or the costs because we have to maintain and administer all these social distancing protocols. All of that stuff. Communicate it so they know that you didn't make the decision willy-nilly. And an upside, you might want to say, we also don't want to be the test case because our firm doesn't know the legal liabilities at this point. We will know in a year from now, but we won't know today. So do you really want to be the test case for this? And then are there any upsides to this? If we close the pool or keep it closed, then here's the money we're saving and maybe we can use it to do X, which everybody wants. So if you have some kind of upside to it, communicate that as well. Finally, what you should consider with pools specifically, again, safe at home order, look at the guidelines. They're specific. Make sure that you're complying with those guidelines, such mainly controlling capacity, and we strongly recommend the reservation system in order to control the capacity. Look at the CDPHE pool guidelines, whatever the local order is with respect to pools, because they're pretty specific. Look at those as well. We already talked about everything here. Consider the feasibility of meeting all of those benefits, the protocols for keeping the bathrooms and cleaning them and all of that. Specific things that we recommend are the registration system. Again, everybody's doing this differently. Some associations are saying we're going to expand the pool hours, 1 more hour on each side, so that, and then we're going to divide it into 1 hour slots. Like if you sign in for this hour, then you get it for that hour. Then we're going to have some time to clean between slots, and then we can let the next people in. So that's one way they're doing it. Others are shortening the time and allowing the maximum number to be in there, but it's very difficult to keep them from 6 feet. So that might be harder to just say anybody can come in. It would be better to have them register so you can control the capacity. Some are saying only swim laps are allowed, and you can do that. You can say, look, we're going to open it, but just for swim laps, because that way we can monitor the social distancing code controls. I would not recommend allowing guests. It should just be residents, because if you allow guests, then that kind of takes away from the already limited capacity. I would recommend a waiver, but a waiver is not the end all be all. It doesn't absolve you from liability. What it does do is it adds a second layer of precaution, saying, we did all this and we told people that they might still get infected, and they waive their right. They waive the right to sue the association. Again, that doesn't waive your negligence. So if you did something egregious and you knew somebody's infected and you let them in, that's not going to waive that, but it's an extra layer of precaution. We do recommend that. Revise your rules and regs, revise the sign, talk to your insurance to see maybe you do have coverage. Get an opinion for that. If you're going to close it and keep it closed, maybe it's good to get an opinion from both your attorney and your insurance saying there's no insurance, and the attorney saying, since there's no insurance and here's the liability concerns, you're positioning yourself for that challenge. Remove the furniture, guest prohibit, no swim teams. I wouldn't do swim teams. I think that, again, addresses the capacity issue. So tip 5, this is my mantra that I've been saying. It's kind of OJ-esque, but if you don't have the ability, then don't open the facility. I mean, that's what it comes down to. Consider everything. Once you do consider everything, make your decision. You will be protected from liability as long as you go through all of that. Okay, I am done with my presentation, and now I know I'm sorry, but it's already 2 after, but why don't we consider whatever the questions are at this point? Do you want me to stop sharing the screen, or I'm going to stop sharing the screen here, and then, okay, all right, so do you want me to go ahead and look into the chat? Are you going to read those, or would you like
why
to
don't we've got quite a few, so okay. Why don't I read them to you? We've got 1, 2, 3, 4, 5, 6, 7 questions.
All right.
Let's do it. We'd love to get to them all. So I'll read them as they came in. So number 1, what are the rules for renting the clubhouse? Maybe we already addressed that.
Yeah, I mean, and honestly, it's the order doesn't really prescribe. They give you a lot of discretion. So all you do is figure out the best way to address the social distancing protocols and put that in writing, what the revised rules and regs for your clubhouse reservation will be. And they have to sign off that they're going to meet all of those. So.
Great. Okay, next question. What are the board members' responsibility what is a board member's responsibility if they see a gathering of over 10 people in the courtyard? And as a follow-up to that, do children count as people in this instance?
Children don't count, but dogs count. No, I'm just kidding. So yeah, it is. They do count. They do count towards the amount. And here's the thing about enforcement. I don't want to see anybody getting into fistfights over this. I have seen that be an issue where somebody's seen an issue and then they go out there and all of a sudden the board is ready to beat up whoever's there. You have to enforce it like any other kind of violation. So if to the extent that it comes to your attention, yes, go out there and say, here are the revised rules and regs. We've already communicated this to everyone. At this point, there's a safer at home order that we have to comply with. So you need to disperse, you need to disband. If they don't, then don't get into any kind of physical alterations, but you need to find out who they are, because that's who you're going to be enforcing against, such as, what do you normally do to enforce a violation? You might fine them. or you might suspend them from using the place. So if it's the pool and they're violating the pool rules, say your suspension, your right to use it is now revoked. We always put that in our waivers. And you should put that in your waivers, or have your attorney draft your waivers, or put that in your revised rules and regs. Put them in both. But enforce it the same way you would normally enforce it. If they're violating some other order, some other provision of the order that's not in your jurisdiction, so it's not on the common elements, then call the local authorities to enforce it. You're not the COVID cop.
Right. Great. Okay, question number 3. We also touched on a little bit. So the current COVID-19 order for Colorado classifies indoor swimming pools with gyms. The language for cleaning and disinfecting is not clear. It refers to equipment being cleaned and disinfected between each use. Would this apply to swimming pool handrails and other commonly touched areas? If not, would we use the once an hour as required for outdoor pools?
So you're right, and that's one thing that's the same with statutes and legislation. There's a lot of ambiguity. I think that is on purpose. They don't want to keep you to some regimented protocol. I think you can use the same kind of guidelines in the outdoor and indoor and use them interchangeably. You can use that because, again, you're just trying to use the language and make the best decision based on what's in front of you, and it's ambiguous. So whenever there's any ambiguity, the board has the right to adopt reasonable interpretations of that ambiguity. You're completely protected there, so you could apply the same if you want to I think it says one area it's once an hour and another area it says equipment, but doesn't say what that means. I think you can use that and say, okay, we're going to apply it to this, handrails or whatever, or we're going to look at the CDC guidelines. They have even more specific types of cleaning protocol that gives time frames and frequency. So you might want to look at that as well. But ultimately, unless what you're adopting is contrary to the order, then you're good. You talk to, I mean, I'm not an expert. I wouldn't know what the regular cleaning authority would be. But ultimately, as long as it's not against what the order says, then you can look at a lot of different guidelines and then come up with your best and go for that. That'll be fine. You can adopt that reasonable interpretation. I wish I had specific answers, but they don't do that. They just give you, Okay.
Okay, next question is, if we have a system to document the individual cleaning and the time of cleaning and disinfecting, can it be done by the individual swimmers and or individuals using the fitness room, or should it be done independently by assigned volunteers or staff?
So I think it's better to do it by by staff or additional hired staff or volunteers, even if anybody's willing to volunteer. I think that the issue is, well, homeowners can do it themselves, but you're not able to really, it's the honor system, and it's better to have a third party address it versus the honor system. Just because, again, when I'm positioning for later on in time, and the court says, well, really, you just put a sign up and let anybody come in and you just kind of assume that they're going to do everything correctly? Shouldn't you have had something that was more objective or something? So I think even though you can do that, it would be better to have the staff. Now, even though volunteers can do it or board members can do it, and a lot of them are doing this, I think it puts them also in a kind of a awkward position, or in a position that they might have altercations or something uncomfortable. So even though you might have volunteers, I think, again, it's better to have that staff, that person that's there, that pool monitor or registration person that is doing just this. That's the best way to position yourself for claims that you didn't do enough. Now, you can do any of those, but I'm just saying the most prudent one is the hired additional staff.
All right, well, I'll ask my box just a second. Okay, next question. Next question regarded indoor-outdoor pools, so I think we got that addressed. Melissa, would you be able to provide links to the statutes / guidance that you're referencing?
Yes, absolutely. Absolutely. What I can do, Frank, why don't I send that to you, and maybe you can send it to everybody? Yeah.
Yep,
okay. Yeah,
absolutely.
absolutely.
I'll send those links along with the recording of this session.
Great.
Okay, two more here. So how would the HOAs regulate and enforce the 50% if we are to stay in our lane, like mentioned before? It's a little bit confusing / conflicting guidance.
Yeah, and if you'll notice that, I think oh wait, what do you mean stay in your lane? Stay in your swimming pool lane, or what do you mean? Or you mean
No, I think stay in lane as a board member as a concept.
Because you're sorry, I'm like going off in a completely other direction here. Like staying in your lane, is that an order? I'm like swim lap only? Okay, so staying in your lane, you are staying in your lane because what you're doing is enforcing your rules and regulations that are based on the order. So you're not enforcing the order per se, you are adopting rules and regulations over the common element facilities that are based on the order. So you are staying in your lane by enforcing your own orders. Hopefully that makes sense.
Great, thank you. Okay. Okay, does, you may have touched on this already, but does imposing a release waiver by users for things like pools, exercise facilities, etc., gain any reduction in liability for HOAs or board members?
I think
you
it does.
Address that a little bit, yeah.
Yeah, it doesn't. I just don't want people to think that that's the, I keep getting statements from boards and managers thinking that that's going to be the end all be all. We're not going to be liable because of this, because they signed off and they said, I assume the risk. That's not true. I mean, you can still be sued no matter what, even though you probably 99% wouldn't be liable, but you don't waive your own negligence you can't waive your own negligence by having somebody sign a waiver. So if you did something, I keep saying egregious because I think by considering all these questions and then putting the controls in place that you're not negligent, you're doing what you can under the circumstances based on what kind of community you have and many. I think something egregious would be something like, you know that somebody's either infected or you allow somebody who is consistently violating the rules to continue to use the pool. I mean, things like that, which shows that you were just ignoring the order. But the waiver is a good second extra layer of precaution and protection. So you can't, you know, it does, in my opinion, waive liability in sort of an indirect sense in that with all of these things and the waiver, it kind of inhibits somebody from wanting to sue in the first place after they talk to an attorney. So, anything else?
That was, oh, we just got one more.
Okay.
Okay, so to clarify on that, and of course a chainsaw just started outside my window. Typical property management problem here. So we are, I hope you can hear me. We are leaving it up to individual members to determine 50% capacity, like counting heads at a pool, and they would self-regulate following the rules, and the boards would not monitor lowered capacity use beyond regular business.
Okay, so again, I don't think that's enough, but if you have come to that decision, maybe it's because you don't have a big traffic in your pool. Maybe it's because only a few people use it, so you don't feel that there's a risk to do that, to not have the additional mechanism. So again, it is okay to adopt this. I don't know whether a court's gonna say that's okay if somebody gets sick. Think about the type of community you have, especially if it's high risk. So when I think about the indoor swimming pools and the high-risk condos, I also think about the 55 and over communities. If they're high risk, there's more chance of lawsuits being filed. So if you still consider that and say, we still want to open it, we're not going to have the additional protection, we're going to let everybody self-regulate, then make sure that's just clearly communicated to everybody. Rules and regs, signage, waivers absolutely have to be signed for that. If there's any if there's any indication that people are not following it based on people who are there who say they're not following it, or somebody else who does come by and decide to check it, if you get any indication that people aren't violating the rules regardless of this self-regulation, I think that you have to make a different decision. You can always change your mind throughout this based on circumstances and facts. And if you find that people are violating it, then I think you do need to hire the pool monitor or close the pool. So at any time, just like the governor said many times, that if things change, if there's a second wave, if people are violating it left and right, I have no problem issuing another lockdown order. The same kind of approach should be by you as a board, which is if people aren't complying or they're just throwing the rules out the door, then we're going to close it. And so just be really, really careful if you're letting people self-regulate. I get it. I get the need to do that, but I get really nervous because there's no insurance for this. And unless it's if it's a pool that a lot of people use, I would not do that. If it's a smaller community with less risk, then maybe that's okay.
Okay, two more quickly here. So another was just a clarifying question. So what is the actual answer to renting clubhouse rules? How many people?
So for the clubhouse, let me see if it's in here. I don't think they address clubhouses. It's just recreational centers. But the general overall rule, let me just say this, the general overall rule, if there isn't anything that specifically addresses it in the order, the specific amenity, is no more than 10 people, no gathering more than 10 people. And of the gathering that's 10 people or less, social distancing protocols of 6 feet. And there are exceptions for family. So again, there's some exceptions. I don't know if there's one about the clubhouse, but what I'm going to do after I get off this and before I send these links to Frank, I will look up. I will search for clubhouse and see if there's anything specific about clubhouse. If not, then you fall back on the general 10 people. Okay. Oops, I think Frank, you're muted.
Whoops. Okay, last thing we have here is a bit more of a big picture question. I'm sure boards are feeling all over the country. I feel like I'm hearing don't police this and then you must monitor to manage risk at the same time.
You have to, don't police the order is what I'm saying. Don't police the safer at home order. Definitely police and monitor your rules and regulations. So if you're going to open the pool, then you open the pool or the facility based on your rules and regulations. And that's what you need to enforce. Now, there's a difference between a pool versus a library. Let's say a pool, there are people there, a lot of people there. So the consequence of not regularly monitoring that through whatever system you employ are much greater than having somebody monitoring the library where very few people might go in, and you don't have to have somebody stationed there to watch the library because it's a lower risk and it's a lower consequence to the association by not having somebody watching or administering the cleaning or monitoring the 6-foot distance, social distancing protocol. So yeah, I do think you need to monitor and enforce your rules and regulations. The only thing I meant about the COVID cop is don't exceed that and enforce things that are not in your jurisdiction, that are things that are in the order that have nothing to do with the common elements. It really has to do just with the common elements. So with those of you who have areas that are in your community but are not part of the common elements, then you shouldn't be applying these regulations to those areas. I think one example would be, let's say you decide that you require everybody to have a mask in the common element swimming pool or in the common element clubhouse. You must wear a mask, and you can do this. You must have a mask, wear the mask at all times while you're using the facility. Then they leave the common element clubhouse and they're walking through the community or the public streets. Even if, let's say your city says every time you're outside of the residence, you have to have a mask on if you're outside in the public, but that public area is not in the common elements, you shouldn't then be enforcing against that person that's walking through the public park or the public streets or whatever other public area that you don't have jurisdiction over. In those cases, if you see somebody walking around without a mask and your city says you shall have a mask on, then call the local authorities. And that's all I meant about not being the cop. Just, you can be the cop with respect to your own rules and regulations. So hopefully that clarified. Anything else at this point?
That's all we had in the chat.
Okay, that's all I have then. Great. So Frank, you are going to be, you recorded this and you'll get a copy to all of us of the recording. We'll also put that on our website, and I don't know if CAP's going to put it on their website, but so everybody who wasn't able to attend can certainly access it. I will find any reference to clubhouses, and if there isn't any, then I'll let you know, but I'll send you the relevant links that you can look at, not just the Safer at Home order and the CDPHE guidelines. I'll send you the CDC guidelines too, because I think those are really good. And as well as the tennis court. I don't know if any of your associations have tennis courts, but there's some great U.S. Tennis Association guidelines that I think just should be used just as written. They're fantastic. Okay, that's it. So I guess unless there's any closing comments from Frank, thank you for joining us. And you know, you can feel free to reach me offline. I think I did put my, did I get my, I'm gonna send this to everybody. Whoops, my email. It's also on the slides, I'm pretty sure. If they have, whoops, that went to Tim, that should go to everyone. Okay. So I just sent my email, so if you guys want to contact me offline or just go on our website, you're free to do so. And thanks again for joining us. I guess I'll sign off.
Thanks everyone.
Frank. Thanks, bye.
Okay. Bye.